Okay, we're at 3 minutes after the hour. We're going to get started. Welcome to our 6:50 webinar this afternoon. Afternoon for me, I'm on the East Coast, or morning if you're like my colleagues on Mountain or Pacific time. But welcome to our webinar, How to Hire Employees in New States in 3 Steps. My name's Ryan Parker. I'm the Chief Legal Product Officer here at 650. If you haven't heard of 650, we're the legal technology subsidiary of the law firm Wilson Sonsini. And we take complicated legal issues and we make them simple by adding thoughtful technology. And so we help companies to comply with complex privacy laws like the CCPA, soon to be the CPRA in California, or the GDPR. And we also help companies with employment issues. And that's what we're going to be discussing today. We have a tool that helps companies hire people in new states. We have a tool that helps people and companies to create employment agreements, and we have a tool that helps companies to create employee handbooks. And so we're thinking about these issues and monitoring changes in the law, and we're going to talk about those issues today. I have with me today my 2 co-presenters, Adrienne Jack. Adrienne is a Vice President of Legal Product here at 650. She's a proud graduate of Northwestern Law School, practiced at some big firms, and joined us as a vice president a little over a year ago. Adrienne helped to build several of these tools and has some great insights. In addition to her legal acumen, Adrienne is a big Taylor Swift fan, loves street tacos, and warm socks, among other things.
Thanks, Ryan. Excited to be on.
Glad to have you, Adrienne. And also we have Adam Wright. Adam's a proud graduate of the University of Michigan Law School, go Blue. And has helped us to develop, in particular, our employment agreements tool. And he's closely tracking developments in the law in that field. Adam clerked for 2 federal judges and has worked for multiple firms before joining us here at 650 as a vice president of legal product. Adam is an avid skier. Unlike me, I like to take the lift down and ski. Adam puts on his cross-country skis up the hill and then skis down. And lives outside of Albuquerque, where he's able to ski almost directly from his house, which is pretty awesome. So we're grateful to have Adam with us today.
Thanks, Ryan. Happy to be here.
So as we get started, we wanted to make this kind of an interactive program. And so I'm going to make a couple of housekeeping announcements, and then we'll dive right in. First, if you have questions, please put them in the Q&A. Use the Q&A button below so that we can monitor and track those. We'll try to answer them as we go. We may answer some of them live, but we'll try to respond to those as quickly as possible. You can also use the chat button, but it's easier for us to track the questions if you use the Q&A. The one question that we get every webinar is, will this slide deck be available? And the answer is yes. We're recording the webinar. We'll send you out a video of the webinar if you'd like it, and we'll send you out the slides so you can look at them later. We try not to put too much content in the slide, but there is some helpful material in there, and so you'll be able to look at the slides after the webinar. And with that, why don't we get started? I'd like to get started with a poll question. So we're going to talk about what it means to have employees in new states. And there are essentially 2 different scenarios that we're going to address. The first is a situation where a company hires someone in a state where they don't already have employees. And so that's hiring a new employee in a new state. The second situation is one in which a current employee comes and tells you they're moving to a new state where you don't currently have employees. And in either of those 2 situations, there are a number of steps that companies have to take when they have employees in new states. And so we want to start by asking a poll question. Over the last 6 months, has your company hired an employee in a new state? 2, had an employee move to a new state. And when I say new state, that's a state where you don't already have employees. Both hired and moved, so that would be A and B, or none of the above. So we'll let you fill that out. Just take a minute. Have you hired in a new state? Have you had an employee move to a new state? Both. You've hired in a new state and had someone move to a new state, or none. And we'll let you vote here just for a minute. I'm interested to see the results just based on the companies that we work with. I have some guesses. We'll give just another couple of seconds for people to vote. And then I'll ask that we put up the results here. Why don't we close our poll, and we'll see how many of you are dealing with these types of situations. Interesting. So here are our results. We have 33%, about a third of you have hired in a new state in the last 6 months. And I think that's representative of what we're seeing in the labor market, is that we're seeing companies that are looking to recruit from a broader pool and are hiring in new states. Only 8% have had an employee move to a new state. I'm a little surprised, although I think that that may have happened. A lot of that movement may have happened prior to this last 6-month period. 44% have had both have hired in a new state and had employees move. That's a really big number. And I'm not surprised. And so I think, most of the people on the webinar are going to be familiar with the challenges we're going to talk about. And then we had 15% that said none of the above. Don't worry, your time's coming. So that's exciting. Very interesting poll results. Thank you for jumping in. Interesting to see. I think that those results are probably somewhat representative of the broader pool of companies, because we're seeing a lot of employee movement. Well, let's move to the agenda, and we'll talk about sort of these 3 steps that we mentioned at the beginning. So we've broken down this process into 3 parts. What to do when hiring in a new state. And Adrian's going to talk about that. That's things like registering as an employer, figuring out whether you need a registered agent to receive the service of process, tax. There's all sorts of different implications. And Adrian's going to talk about how companies can address those types of issues. The second is when you actually put together the hiring paperwork, how to customize offer letters and employment contracts. There's some significant differences among the states, and Adam's going to address that issue. And then I'm going to close up by talking about employee handbooks. When you get someone in a new state, what does that mean for your employee handbook? What do you need to do, and what processes should you be thinking about putting in place? So with that, I'm going to turn the time over to Adrian, who's going to talk to us about the steps we should be taking when we hire in a new state.
Thank you. There are definitely some issues to think about. So as companies consider hiring employees in a new state, or consider permitting an employee to relocate to a state where the company doesn't already have employees, there are varying laws that impact how the company could either consider new job candidates or to allow that employee to relocate to a new state. So the first hiring parameter is to think about what are the protected characteristics in that state. So federal laws and the laws of every state prohibit discrimination based on certain protected characteristics. These protected characteristics are defined by state law. There is a set of federal law protected characteristics, but every state has their own list of what are protected characteristics in that state. And these can range from protected characteristics like race, color, religion, sex, sexual orientation, and other similar protected classes. But we're seeing some movement in this space of states that are adding new protected characteristics to that list. And so it's a best practice to think about and look into what are the protected characteristics in that state, especially if a company is going to be opening a job posting in that state or evaluating new candidates. They want to make sure that they're following the law in that state and not discriminating on any protected characteristics. So we've seen California, Colorado, New York, New Jersey, and Washington and Virginia actually enact legislation adding traits historically associated or perceived to be associated with race, including hair texture and protective hairstyles, to their laws against discrimination. So this is a new protected class that hasn't been on the list before, but at least 5 new states have added that protected characteristics, and other states might follow suit. So these protective hairstyles include things like afros, braids, locks, or twists. That's something companies want to be aware of as they're evaluating new candidates to make sure that they're giving each candidate an equal opportunity for employment. Next, there are limits on criminal history, on how companies can evaluate a candidate's criminal history, what they can take into account, and when in the process they can do so. So we've seen New York City, they have a Fair Chance Act, and this law was implemented in 2015, but it's been amended since then to kind of even tighten the limitations on companies and how they evaluate a candidate's criminal history. So the Fair Chance Act applies to companies with 4 or more employees, and it prohibits them from inquiring about a potential job applicant's criminal history before making a job offer. And then if they have already offered a candidate a job, in order to revoke that job offer based on a candidate's criminal history, they have to engage in a detailed process indicated by the Fair Chance Act. And this act lists factors that can be evaluated when taking into account an individual's criminal history. And then it also requires certain notices to the employee about how the employer takes into account those characteristics. And interestingly, some of the new movement we've seen on this is indicating a set of factors that the company consider for arrests and convictions, and then one for pending arrests and convictions. So the company has a list of up to 8 factors to think about and evaluate when they're looking at a candidate's criminal history. So if that's something that your company looks into when evaluating new candidates, you want to make sure that you're looking at the state law and what you can take into account and when in the hiring process you can take that into account. And detail that information and keep that on company records to show that you're complying with that state law. There are also state limits on credit reports and background checks. The Federal Fair Credit Reporting Act stipulates how and when employers can obtain a consumer report about an applicant or an employee. Consumer reports can include a broad range of categories like driving records, criminal records, credit reports, or other reports such as from third parties like a drug test. And under the FCRA, an employer has to provide an applicant with a clear and conspicuous disclosure that this consumer report will be obtained, and then also can obtain that applicant's written consent to obtain the report before requesting that report. And then once the company receives a consumer report, if the company intends to take an adverse action like not hire or terminate an employee, based on the information contained in that report, they have to provide specific notice to employees prior to the adverse action and then after the adverse action. So that's the federal law, the FCRA, but states have different laws regarding background checks and specific language that companies have to provide to potential applicants or current employees about how the company intends to obtain the consumer report, what it might be used for, and then if a company decides to act on that report information, they have to provide to the employee and a potential to correct the report or appeal the company's decision. Each state has different laws. And in 2019, we saw an interesting take out of this from the Ninth Circuit, which covers 9 states, including California, Oregon, and Washington, and states along the West Coast. And they held that a company that had provided an applicant disclosure, the written disclosure by the FCRA before obtaining the consumer report, they also included the state-specific disclosure in that form, saying under federal law, we're providing you this information, and then under California's background check disclosure laws, we're providing you additional information, and referred to both sets of information in that consent form. And the Ninth Circuit held that that information was not a clear and conspicuous disclosure because it included both federal and state disclosure requirements and then some other information that was unnecessary to the exact disclosure that was required. And so companies need to make sure that if they are obtaining a consumer report or a background check for an employee in a state that's in the Ninth Circuit, that they are complying with those notice requirements and including a specific FCRA disclosure, as well as any state-specific disclosures separately to employees, and not including any extra information in that written consent and disclosure form, because that might violate the law in those states. And so if your company obtains background checks or consumer reports, you want to make sure you know the federal law, but also the state-specific law and any procedures there, and then are complying with the law when you're obtaining those disclosures or obtaining those consents and providing the disclosure. And like the background check and criminal history laws, there's also limits on how and when companies can administer drug tests to applicants or employees, and those can be state-specific laws. And so that's something that companies need to evaluate for a potential candidate or on an ongoing basis for employees. So once a company decides to hire an employee in a new state or allow an employee to relocate to a state, they need to take several different steps to register and set up different accounts in the new state. So we're going to move to the next slide and talk about what are these registrations and setup requirements for companies in a new state. So almost every state has a law that requires a foreign entity, which means an entity that was not formed or incorporated in that state. They cannot conduct or transact business until they have obtained a certificate of authority or have consent to do business in that state. Registering as a foreign employer often requires obtaining a certificate of authority in that state. It also might require having a registered agent, as some states dictate that you have to have somebody who can receive mail with a physical presence in that state in order to be registered there. And with the switch to many employees becoming remote during the pandemic, not a lot of state laws have caught up with this requirement of, is this required if you only have a remote employee working in a state? Does that constitute conducting or transacting business? Not many state statutes say one way or the other, but it's definitely a best practice to go ahead and register in that state, as having an employee does constitute a physical presence there and likely would constitute conducting or transacting business. And so this is often the first step in the process, a gatekeeping item, because many of the other registrations or process requirements are contingent on the company being registered to do business in the state. Next, companies need to register for different tax accounts. So we'll move forward to the next slide. And these can be a variety of tax accounts. They can be income, withholding tax accounts, and we'll talk about this in more detail shortly. They can also be sales and use tax accounts. Previously, so prior to 2018, companies had to have a physical presence in a state in order to be required to pay sales tax in that state. There had to be a physical nexus there. So that means they had to have a presence in the state, whether it was a building or an employee or some other physical nexus to that state. But in 2018, the US Supreme Court's decision in South Dakota versus Wayfair kind of opened this box of what it means to have a presence in a state. So companies no longer need to have a physical presence in the state to be subject to sales tax there. If the company has an economic nexus or constitutes some economic activity in that state, they might have an obligation to pay sales tax in a state. So companies are often going through this analysis of, if they don't have a physical presence, do they have an economic presence in that state? And are they required to pay sales tax there? The economic nexus is usually based on a certain amount of revenue obtained in the state. It can be a threshold as low as $100,000 or as high as $500,000, or it can constitute a number of transactions in that state. So it could be they have $100,000 of sales, or they conduct 50 transactions in that state. So if companies meet that threshold, they're subject to sales tax in that state. And having an employee in a state is the physical presence and will trigger a sales tax requirement. And so companies need to be prepared, if they're not already paying sales tax in a state, that by having an employee there, they will be subject to sales tax and need to register for a sales and use tax account, and then remit, it can be quarterly or yearly sales tax contributions to the state. Next, we'll talk about income withholding requirements. So if an employee is earning income, and let's move to the next slide. If a remote employee is earning income in a state, the company is required to withhold income tax from that employee's from those employees' taxes, or from those employees' salary, in that state, and then remit those to the state. But unfortunately, when that requirement is triggered differs based on each state laws. So 8 states have withholding thresholds for non-resident employees, and say if they meet time thresholds, like they're working in the state a certain number of days, then the company is required to withhold income taxes from that employee. And so that could be like in Arizona, if an employee is there for more than 60 days, the company is required to pay or to withhold income taxes and remit those to the state. 6 states have wage or income thresholds for employees. So that means the employee is earning a certain amount of a dollar amount in that state. And once they hit that dollar amount, the company is required to withhold income taxes. So that could be like in Idaho, if an employee earns $1,000 of in-state revenue, the company is required to withhold on that employee. 2 states have a combination of both income and a time requirement. And then 22 states and the District of Columbia don't have a threshold indicated. So that means hypothetically, a company is required to withhold from an employee's income taxes on day 1 of being in that state. So companies that are planning on wage withholding need to do so right away. But if employees are working temporarily from different locations, companies need to pay attention to when is this required. And it becomes more complicated too with reciprocal state agreements. So states can agree, there are at least 15 reciprocal agreements where neighboring states will say, okay, you don't have to withhold in this state if you're already withholding in this state. So that makes this matter more complicated of looking at where is the withholding requirement and when is that triggered. Okay, let's go to the next slide. Next, there are employment registrations. Each state requires that a company report a new hire to, it's often the Department of Labor, but it can be a different department, to notify them that an employee is in the state. And this helps to, this data is then reported to make sure that child support orders are fulfilled and that there's no fraudulent government payments, that somebody's not getting unemployment insurance in one state, but then working in another state. It helps kind of reconcile and avoid that type of fraud. Companies also need to have workers' compensation coverage up and ready to go. Almost every state has a workers' compensation coverage requirement. Some of it can be through private insurance, but some of it must be through the state specific workers' compensation fund. And so companies need to make sure they're aware of that requirement and meeting that requirement. As well as unemployment insurance is required in almost every state, and companies need to make sure they are meeting the unemployment insurance requirements there. And then there can also be paid family and medical leave registrations required. In states that have family leave that's required, most of the time it just requires the company to provide that to an employee through a company's payroll system. But sometimes the employee is able to get paid family and medical leave from the state, and the employer needs to submit contributions on behalf of that employee in order for the employee to be eligible for that. And so companies need to make sure that if there is a registration requirement, they are registered and then they're remitting contributions if that's required. Okay, let's go to the next one. There are also a slew of other considerations. There's so many issues to think about. I wanted to highlight them here. I won't go into detail on all of these, but at-will employment is, most states allow companies to have at-will employment except for Montana that does not. And so if companies are hiring an employee there or allowing an employee to relocate there, they need to make sure that they're aware of that and they're meeting the requirements for terminating an employee if it's not at-will employment. Minimum wage laws differ by state, sometimes by county and city as well. So companies need to check that law and make sure they're complying, as well as pay frequency requirements. This one doesn't seem like a big issue, but it can be complicated if a company's payroll is set up to pay employees every month, but they hire an employee in a state that requires employee to be paid twice per month. And so each state has different laws about how frequently employees must be paid, and companies need to pay attention to that. And in some situations, it can be as frequently as weekly. And so for certain types of employees, even in certain industries, there are different requirements there. Training requirements, there can be different training requirements in each state. A big one that we're seeing right now is sexual harassment training that's required in at least 7 states, but more could be coming soon. And so I'd like to jump to a poll question really quickly and ask, does your company conduct sexual harassment training? And if so, do you conduct it as a one-time training, like when an employee is onboarded? Do you conduct it annually or every 2 years, or do you not conduct sexual harassment training? And while you're answering that question, I just wanted to flag that like California, Connecticut, Delaware, Illinois, Maine, Maryland, and New York and Washington all have this sexual harassment training requirement. Some states, it's a one-time requirement, but other states like Illinois and New York, it's an annual requirement. So if you're hiring an employee in one of those jurisdictions, you want to make sure that you're providing that training if you're required to by law. And even if you're not required to, it's often a best practice to provide this type of training and to refresh employees on that. So let's look at the poll results. Oh, awesome. Okay, so 70% of companies are conducting annual or every 2 years sexual harassment training. That's fantastic. And it looks like 10% are doing a one-time training and 20% are not providing that. So especially for those companies that aren't providing sexual harassment training at all, that's something to pay attention to when hiring, to make sure that if you're hiring in a jurisdiction that requires this, you're going to be ready and able to provide that to employees. Okay, let's go back to that last slide. And I just wanted to mention a couple more things. Some states, like California, are requiring companies, typically smaller companies who don't have a qualified retirement plan, like a 401k plan for employees, that they have to register with the state and allow employees to participate in the state's 401k plan. So we've seen 9 states that have approved a law requiring this, but that only one of them is currently in effect. Only California requires companies to currently comply with this. And that requirement for smaller employers with 5 to 49 employees have to register by the end of this month. But the other states that are implementing this requirement have it effective later this year or even in 2023 and beyond. So if your company doesn't have a qualified retirement plan, like a 401k plan, you need to make sure that the state where you're hiring an employee, you need to check whether or not that state requires you to provide one through the state program. COVID regulations are always on the move. They were quiet for a while, but I think they're picking back up again. We're seeing new mask mandate requirements. So that's something to check in the jurisdiction where you're hiring an employee, as well as making sure your insurance coverage can extend to that employee if you have health and medical benefits to employees through insurance. And then finally, any labor posters or notices. Each state has different laws about signage that has to be posted to employees. And that posting requirement in some states and in a lot of situations can be met by a virtual distribution, like an email, posting on the internet, but you need to make sure that the employees have access to that information and it's readily accessible and conspicuous for them to be able to see that. And then the last slide, I just wanted to reference that all of these different registration requirements and employment implications also vary on a county and city level. So you need to check these not just on the state level, but on the county and city level. And as we looked at this complexity, it kind of led us to create a 50-state hiring kit where we include all of this information about what registration is required, when it's required, where to go to register, to help companies when they're hiring in a new state think about what are the issues that I need to be thinking about. And then once I've decided to hire there, how can I go ahead and meet all of those requirements and hopefully have that information in one place. Okay, thank you. I'm going to turn it over to Adam now to talk about different considerations to draft an offer letter and employment agreement.
Thanks, Adrian. So, the ability to hire employees across the country really has, potentially huge benefits for employers, right? The labor market really opens up. It's especially important when there's a tight labor market and you potentially have access to all sorts of talent that you didn't have access to before. But this also comes with challenges, as we've seen from Adrian. But unfortunately, these challenges also extend to how you craft your offer letters and employment contracts. So if you have employees in different states, no longer can you use one form offer letter and employment agreement and be confident that those documents are legally sound. So we'll start here by talking about issues that you need to think through when you're drafting offer letters, and then we'll move on and talk about employment contracts. So the first thing, which I already hinted at, is that you don't want to use the same form of offer letter for employees in different states. And that's because the law governing your relationship with your employees will likely change based on where that employee works. So generally speaking, the law of the state where your employee is located is going to be the law that governs your relationship with that specific employee. So, even if a company is headquartered in Texas, let's say, and you have 50 employees in Texas, if you have one employee working in California, it will likely be California law that you're going to have to comply with when it comes to employment law and that employee. And that's even if you have a contract provision saying that the parties agree that Texas law will apply. So courts often won't honor those choice of law provisions if in a contract you state that the law of another state, a state other than where the employee is located, is going to govern. So the bottom line here is that if you have employees working in different states, the employment law governing those employees may be very different. When it comes to offer letters, there's no state that has a legal requirement that you use offer letters, but it is definitely a best practice. So it increases transparency and it ensures that the company and employer are on the same page, from the start of employment. And so offer letters are an ideal place to communicate salary, schedule, whether the position is exempt or not. You can describe benefits, eligibility for bonuses, whether the position is in office, remote, or hybrid, and a whole host of other things. But in addition to that, offer letters also need to take into account a recent trend that we're seeing across the country. And that is that states are increasingly requiring notices and disclosures prior to the start of employment. And the offer letter is really an ideal place to include those to make sure that you're complying with the applicable state law. And this is where the state-by-state differences, I think, really come into play with offer letters. So we're seeing this notice disclosure trend in many areas of employment law, but I'll talk about two specific areas that I think really highlight the issue. The first involves wage transparency laws, and the second involves non-compete and non-solicit laws and the notice requirements that go along with those laws. So first, we'll talk about wage transparency notices. So in recent years, we've seen states across the country passing laws that are aimed at increasing wage transparency in the workplace. Many of these laws require wage transparency disclosures at the job posting stage, but there are some states that may require it when an offer of employment is made. And an offer letter is the obvious place to make that disclosure. So there are a lot of states with laws like this, but I've picked Connecticut to look at that I think is a good example and really highlights what's going on in this trend. So even if you don't have an employee in Connecticut, I think this is probably still relevant to you because it gives you an idea of where employment law is going and what may be a requirement in another state as well. So even if your business is not located in Connecticut, if you have a Connecticut-based job applicant, you need to comply with this law, which requires that a company disclose the wage range for the position by the time it makes an offer of employment, or earlier if the applicant requests it earlier. The law also applies to current employees, meaning that if you offer a current employee a promotion, that you're gonna need to disclose the wage range of the job you're offering by the time you offer that promotion. And this, I think, is where things can kind of get tricky with this law, because let's say that you initially hired an employee in Missouri, and you recognize that Missouri law was governing your employment relationship with this employee. But then during the pandemic, this employee relocates to Connecticut, and after they relocate, you offer them a promotion. Well, they are now in Connecticut, and they are now subject to Connecticut law, which means the employer is now subject to Connecticut law and needs to comply with Connecticut law. So even though the company wasn't thinking about Connecticut law at all when they hired this employee, now suddenly the company is subject to this wage disclosure requirement under the Connecticut law. So the law has a specific definition of wage range, which is the range of wages an employer anticipates relying on when setting wages for a position, and may include reference to any applicable pay scale, previously determined range of wages for the position, an actual range of wages for those employees currently holding a comparable position, or the employer's budgeted amount for the position. So, if you're a Connecticut-based company, or if you often hire employees in Connecticut, it may be a best practice for your company to go ahead and create, set wage ranges for each position, and then include those as a matter of course in your offer letters. So, the takeaway here, if you're extending an offer to a Connecticut-based employee, you should make it a practice to include the wage range for the position that you're offering. Okay, let's move to the next slide, and we'll talk about notice requirements when it comes to restrictive covenants. So when I say restrictive covenants, I'm referring here to provisions and agreements like non-compete provisions or non-solicitation agreements. You may know a non-compete agreement restricts an employee post-employment from competing with the employer for a specific amount of time and in a specific geographic range. Non-solicit agreements are somewhat similar. They impose a little bit less burdensome restrictions on the employee and prohibit them post-employment from soliciting the company's customers, employees, or other third parties like vendors or suppliers. So here, states across the country and really across the political spectrum are introducing and passing laws to limit employers' use of non-competes and also non-solicits, but to a lesser extent. And we'll talk more about this in a second when we talk about employment contracts. But as it relates to offer letters, many states are now requiring employers to give employees advance notice that they're going to have to sign a non-compete or non-solicit agreement. And some states also require employers to give employees a certain amount of time to review the terms of that non-compete or non-solicit before beginning employment. And so, these requirements, obviously, these notice requirements will affect your offer letters in many ways. One, you're going to be wanting to put that notice in your offer letter. But two, it's going to affect the start date of employment that you communicate to the employee. And also it will affect the date that the offer expires, right? Because if you're going to ask this employee to sign a non-compete, and let's say under the applicable state law, you have a 14-day required notice period, you can't give an offer letter on day one and say that that employment is going to begin on day 8, because if you do that, the non-compete is not going to be enforceable. So there are some states that go further and require the employer to affirmatively advise the employee to consult an attorney before signing the non-compete or non-solicit. And the risk here, if the required notice or disclosure is not given, you're going to have an unenforceable non-compete, and you may also be subject to damages and civil penalties depending on the state. And currently, states with notice and disclosure requirements are Illinois, Massachusetts, Maine, Minnesota, New Hampshire, Oregon, Washington, and then Colorado just passed a new, very strict non-compete law that's set to go into effect August of this year. And we can expect more states to join this crowd very soon, I think. So Washington, D.C. has a new law that goes into effect in October that bans non-competes and requires the employer to affirmatively disclose to employees that non-competes are not allowed in D.C. And failure to give that notice can subject the employer to pretty hefty fines. This year, we have 66 non-compete bills pending in 21 different states, spanning the political spectrum from South Carolina to New York. So I think there's a clear trend here. And so we can expect more states across the country to be implementing these notice and disclosure requirements. And I've given an example here at the bottom. I sort of already alluded to this. It's just the requirement that you're giving enough notice, and the result potentially, if you don't, is that your non-compete is going to be unenforceable. Okay, so let's transition now to talk about how to craft state-specific employment contracts. But before we do that, we have another poll question for you. And that is, does your company use the same form employment agreement for employees located in different states? Yes, no, or your company doesn't use written employment agreements. And I'm really interested to see the results here. I suspect that this practice may have changed over the last couple of years, but it'll be interesting to see the results here. I'll give maybe another 5 seconds to answer that, and then we'll take a look at the results. All right, let's close the poll and take a look here. So about 60% of you said that your company does use the same form employment agreement for employees located in different states. 13% don't, and then 28% don't use written employment agreements at all. So for the companies that are using the same form of employment agreement for employees located in different states, hopefully this presentation is somewhat enlightening, and you can sort of see the areas where that may be problematic. And for companies that don't use written employment agreements, I think that there may be some issues there with ensuring that your company is adequately protected. And certainly written employment agreements are an important way to protect your company's trade secrets, confidential information, and other aspects of the business as well. So let's talk about drafting employment contracts and how you might do that with a remote workforce. So like with offer letters, companies really shouldn't be using the same form employment contract for employees in different states. Doing that, I think, poses some real risks, which we'll talk about. There are many areas of employment law that are moving very quickly. We already talked a little bit about non-competes and non-solicits, but other fast-moving areas of the law include non-disclosure and confidentiality agreements, as well as the law governing arbitration, just to name a few. So we'll talk through some of the steps here that employers can take to make sure they're adequately protecting their companies with enforceable employment contracts. So first, your employment contracts need to be state specific. And as we talked about, as a general rule of thumb, the contract will need to comply with the law of the state where the employee is located. So the obvious first step here is to know where your employees are located, so you can make sure that your contracts are complying with the applicable state law. So to do that, I think it's really important for a company to have a strong relocation policy in place. So at minimum, companies should require employees to provide notice of relocation, so you know where your employees are. But at the other end of the spectrum, a more strict approach would be to require pre-approval of any relocation, and then you have an opportunity, to look at the state's law where the employee wants to move and think, okay, I'm willing to have an employee in this state, or you may come to the opposite decision. For example, if you are a company that relies on non-competes to protect your trade secrets and confidential information, you may not want to permit a employee's relocation to North Dakota, California, or Oklahoma, where non-competes are banned. Alternatively, companies could set, have a pre-approved list of states where they've determined they're willing to have employees, and then employees can move to those states, without consent from the employer, or without pre-approval from the employer. So for new hires, again, you need to make sure that your contract complies with the law of the state where your new hire is. So there are many contract provisions that need to be very state specific to be enforceable. But this, is true for many areas of employment law. But three big ones that I'll focus on here are not restrictive covenants like non-competes and non-solicits, NDAs, and arbitration provisions. So with non-competes and non-solicits, we already talked about disclosure requirements that can vary, state by state. We've already talked about states that ban them, like Oklahoma, North Dakota, California, and soon Washington, D.C. But there are many other state differences in non-compete and non-solicit law. One trend we're seeing is that many states are including income thresholds in their non-compete laws, meaning that if an employee doesn't make a certain amount of money, then you can't use the non-compete with that employee, and it's unlawful to do that. States with income thresholds are Oregon, Washington, Maine, Illinois, Virginia, Nevada, soon Colorado. And again, this year, there's a whole host of other states that have introduced legislation that would impose income thresholds. And the income thresholds can be pretty high. Like in Oregon and Washington, it's over $100,000. So if your employee doesn't make that much money, again, it's unlawful to include a non-compete. In every state, there are restrictions on the geographic scope and duration of restrictive covenants, and those restrictions vary greatly state by state. So to ensure you have enforceable restrictive covenants, if you use them, they need to be very state specific. The same goes for NDAs. So in recent years, states have been very active in limiting employers' use of non-disclosure agreements. Historically, companies use them to protect, not only to protect their trade secrets, but also to prohibit employees from disclosing unlawful conduct that happens at the workplace, like discrimination or harassment. And it's really this use of NDAs that states are moving to prohibit. So states that have NDA limitations right now are California, Illinois, New Mexico, New York, Tennessee, and Oregon, and there are several more. I should say, though, even in states where NDAs like this are allowed, it may not be a best practice to include, and a company should really be thinking hard about the kind of work culture they are fostering if they're including NDAs that would prohibit an employee from disclosing unlawful employment practices. And then finally, arbitration. Arbitration provisions are typically governed by a federal law known as the Federal Arbitration Act, or the FAA, which is very friendly toward arbitration. And the FAA usually preempts state laws that try to limit employers' use of arbitration. But recently, there have been a whole host of states that are trying to get creative and get around FAA preemption, and have passed state laws that prohibit employers from requiring employees to sign pre-dispute arbitration agreements that would require arbitration of employment claims. The fate of these laws is really undecided. And so if you have employees in these states, which include California, Illinois, New York, Washington, you probably want your employment contract to account for these limits on arbitration. Again, this is an area of law that's moving very quickly. There was an amendment at the federal level to the FAA recently that now bans pre-dispute arbitration agreements that require employees to arbitrate sexual harassment and sexual assault claims. So you should remove those from your those claims from your arbitration agreements. We saw just earlier this week, the Supreme Court issue a big decision on California's Private Attorney General Act, or PAGA, ruling that PAGA claims can be arbitrated. There was a prior California Supreme Court decision that had said the opposite. And so as of yesterday or the day before, PAGA claims in California now can be arbitrated, which is a big deal for California employers and employees alike. So for relocating employees, again, make sure the law, make sure you know where they are, if they are relocating, where they are relocating, and you need to make sure that the contract is complying with the law of the new state, and you may need to execute a new or modified contract. And the risks of noncompliance can be steep. In some states, simply entering into an unlawful NDA or non-compete can subject the employer to really big fines. Like in Washington, even if you don't try to enforce an unlawful non-compete, simply having an employee sign a non-compete that doesn't comply with that state's non-compete law subjects employers to a $5,000 statutory penalty. When it comes to NDAs, if you have an employee enter an unlawful NDA in Washington, you're subject to minimum damages of $10,000. And then under Colorado's new law, there are similar penalties for even presenting an unlawful non-compete or non-solicit to a worker, even if they don't sign it and if you never try to enforce it. So again, the penalties can be steep, and it is important to ensure, again, the takeaway here is that your employment contracts and offer letters are complying with the law of the state where your employee is located.
I do appreciate the presentations we've already had. There's a lot of complexity with these first two steps, right? What you need to do when you hire someone in a new state, when it comes to employee registration and the like. Then you turn to your agreements. If you get your offer letter and your agreement right, you're not quite done, and you have this third step. And the third step is your employee handbook. Employee handbooks have changed over the last few years as we've moved to a more remote and dispersed workforce. And they can be both more important than ever and more difficult to update. And so let's start with why they're more important. I think before, when most employees worked in an office location with other employees, they were able to ask other employees about practices or policies in a much more easy and natural way. Or maybe they were able to walk down the hall and stick their head in and talk to an HR professional at the company. Now that employees are working often from home or at different times, or maybe even in different states, the employee handbook has become and can serve as a source of information. So if someone gets a jury duty notice, for example, instead of having to call their HR person, they may be able to look in their employee handbook and see what a company's jury duty leave policy is, understand when they have to give notice and how much leave they can have. And so I think as far as policies, employee handbooks have become more important than ever. And also when it comes to establishing company culture. Now that we have more remote employees, the employee handbook is an opportunity for a company to establish and reaffirm its culture and the type of employer that the company wants to be. And so I think employee handbooks are playing a more important role potentially than they have in the past. And they have also become more difficult to keep up to date. And we're going to talk about two reasons why that's the case. The first is that as people move to different states, employee handbooks have to meet the requirement for each state where they have employees. Much like with employment agreements, there are different employment laws that govern employees in different states, and that covers things like leave and all sorts of different policies. And so that makes the employee handbook much more difficult if you have employees in different states. The other thing that we're seeing is frequent changes in employment law. And so as you're monitoring more states, as you're updating your handbook to include the states where you have employees, you also have taken on the responsibility of keeping those handbooks up to date and keeping up to date with the changes that occur to employment law in the states where you have employees. And so that's a pretty significant burden. Let's start by looking at the difference between employment policies that are required in different states. If we can move to the next slide. So I've chosen just a couple of states that are neighbors and right next to each other as you're moving west to east. In California, you have a long list of required state policies. And when I say required policies, most of these policies don't require that you have a written policy in your handbook, but what they do require is, as an employer, that you take certain actions, like providing leave. And typically the best practice is to have that in a written policy so both your HR professionals can follow it and your employees can understand it. And so California has a lot of different requirements on employees, and some of those include local requirements. So if you look at paid sick leave, you have separate policies for Berkeley, Emeryville, Los Angeles, Oakland, San Diego, San Francisco, and Santa Monica. You also have employee thresholds. So for organ bone marrow and blood donor leave in California, your requirement kicks in when you have 15 employees. But when you're looking at domestic violence leave, it kicks in at 25 employees. And so you have some things that are hard to keep track of. For other things, you have a 50 employee threshold. As you move east, you go to Nevada, and you can see that list is a little smaller. In fact, about half. And then as you move farther east to Utah, the list gets even smaller. And so there is significant variation among the states about what is required as far as leave and what policy should be included in a handbook. And so when you hire someone in a new state, it's important that you consider, what do we need to do to our employee handbook to be responsive to the fact that we now have employees in new states? The second challenge that we were talking about is updating, and we'll move quickly onto this one with the next slide. Keeping employee handbooks up to date is challenging for two reasons, and I touched on these already. One, we're seeing more and more changes to state employment laws. Adam touched on some changes that we saw to employment agreements, but we're seeing similar changes to the types of laws that affect your employee handbook. And then as employers are having to monitor more and more states. So let's look at an example, and I think it's a timely one if we move to the next slide. New Mexico has a new paid sick leave law that goes into effect on July 1st, 2022. So in a little over 2 weeks, employers in New Mexico will be subject to a new paid sick leave law. And these employees have to provide 1 hour of leave for every 30 hours of worked, up to a total of 64 hours per year. And so that's the kind of law that if you're not watching, if you've hired someone in New Mexico last year, for example, and you updated your handbook, and then you've kind of forgot about your handbook, you may not see this law coming through. The law also has work site posting requirements. So you have to have ways of letting your employees know about this new paid sick leave law. And laws like this are changing all over the country all the time. And so the more states where you have employees, the more states where you have to be thinking about the law and monitoring it. And I think that's a real challenge. The other challenge is how to format your employee handbook. And this is something that I think is really interesting as companies have moved into more and more states. So let's move to the next slide. There's essentially 4 ways that we're seeing companies organize their employee handbooks, because a lot of companies have in the last couple of years moved from just having one handbook that covered the policies in one state to handbooks that have to account for employees in multiple, maybe even dozens of states. So one way that we've seen employees go is with a universal handbook. They essentially set their handbook policies at a high level that essentially is about 80% California, 10% New York, maybe 10% Vermont, but they set it at the highest level so that no matter where they hire people, they have what we would call a universal handbook. It's one policy that governs all of their employees all across the country. A second version is a state-specific handbook. This is one where they have state-specific policies for each state where they have employees. And so if you're looking at bereavement leave, you may get more bereavement leave in California than you do in Arkansas and than you do in California, and it will tell you the exact amount depending on where the employee is. And so they'll have a policy with state-specific sections. The third option is what we call an addenda. It's one handbook. Often we've seen companies that have sort of a California policies, and then in the back they have addenda for each of the states where they have employees. And this is often for companies that have, a large portion of their workforce in one state, and then they have a couple of people that are working outside that state. They'll add an addendum for each state, and they'll have their sort of library of addenda in the back, and people can go and look at it. And that's an easy way to update an employee handbook. And the last that we're seeing is some companies just create separate handbooks for each state. They just say, okay, we're gonna have a California handbook, a Nevada handbook, a Utah handbook, and they create those and they update them and they keep them separate. And that keeps employees from looking at the benefits that other employees are getting. And there's some benefits there. So I wanna just have a poll here, and we're just almost to the end, but I'm interested in hearing what format your company uses if you have an employee handbook. So why don't we pull that up? This will be our last poll, and we're almost to the end, but I'd love to see how people are organizing their handbooks in this new environment where most companies have employees in an expanding number of states. We're at the very end, so we're going to keep the voting time short. So we'll give you another 5 seconds here. But if you want to vote we're interested in hearing how you organize your employee handbook. Okay, last 5 seconds. And let's pull up our results. Interesting. So we've got a bit of a split. No one uses the separate handbook. So I can see why. 69%, that's a really big number. I'm a little surprised at that, but I think that's interesting. Use a universal handbook, and then we have about an equal split for state specific or addenda. I think it's important to think about what format makes sense for your company, both for the ease of use by your employees and also for updating. So I want to just close here by saying we've covered a lot of complex topics, from registering in different states and what you need to do when you hire, to hiring and hiring paperwork, to handbooks. There's lots of different things to take into account, and there are a lot of tools out there that can help you. We've put together a tool set. Essentially, it has 3 different tools: a 50-state hiring kit that walks you through what you have to do, a 50-state employment kit that helps you to customize your offer letter and your employment agreement to any of the 50 states in the District of Columbia, and a 50-state handbook that helps you to create a handbook in any of the formats we talked about: universal, state-specific, addenda, or separate, and helps you to keep it up to date. We give you a monthly update on the law. And so if you're interested in learning more about our solutions, feel free to visit us at 650.com and book a free demo. But we really appreciate you joining us on this webinar. We think it's an interesting topic and one that's affecting a lot of businesses. We hope that you found it helpful and that you will join us in the future for one of our upcoming 650 webinars. And with that, thanks for coming, and we'll sign off.